New Hampshire may be known for its live free or die motto, but when it comes to rental housing, the state has clear expectations for landlords. New Hampshire's habitability requirements are found in RSA Chapter 540-A, the Landlord-Tenant Law, along with RSA Chapter 48-A, which establishes the state's minimum housing standards. That dual framework is important to understand. RSA 540-A addresses the landlord-tenant relationship broadly, while RSA 48-A gets into the specifics of what a habitable dwelling actually looks like. Together, they give New Hampshire a solid set of rules that landlords need to follow. Under New Hampshire law, landlords must maintain the premises in a condition fit for human habitation. Specifically, you're required to keep the structure weather-tight and in good repair, maintain plumbing and sewage systems in working order, provide adequate hot and cold running water, ensure electrical systems are safe and up to code, provide heating facilities capable of maintaining a minimum of 68 degrees Fahrenheit in habitable rooms, which matters significantly during New Hampshire's long and harsh winters. Install and maintain working smoke and carbon monoxide detectors. Keep the property free from insect and rodent infestations, and maintain common areas in a clean and safe condition. The minimum housing standards under RSA 48-A add more detail. They address things like minimum room sizes, adequate natural lighting, proper ventilation, sanitary conditions, and the structural soundness of floors, walls, ceilings, and stairways. Local code enforcement officers are authorized to inspect properties for compliance, and violations can result in orders to repair and potential fines. New Hampshire has a clear tenant remedy process. If a landlord fails to maintain habitable conditions, the tenant can provide written notice of the defect. If the landlord doesn't respond within a reasonable time, typically 14 days for non-emergency issues, the tenant can pursue several remedies. One of the more notable remedies in New Hampshire is the right to petition the court for a rent escrow. Under this process, the tenant pays rent to the court rather than the landlord, and the court holds the funds until the habitability issue is resolved. This protects both parties. The tenant shows they're willing to pay, and the landlord has a financial incentive to make the repair. New Hampshire also allows tenants to report violations to local health or building officials, seek damages in court, and in cases where conditions are truly uninhabitable, terminate the lease. The state has anti-retaliation protections under RSA 540-A. Landlords cannot increase rent, decrease services, or attempt to evict a tenant in response to a good-faith habitability complaint or request for inspection. This protection applies for 6 months after the tenant exercises their rights. One practical consideration unique to New Hampshire: many rental properties in the state are older, especially in historic towns like Portsmouth, Concord, and Keene. Older properties often come with challenges like aging heating systems, outdated wiring, and potential lead paint issues. Staying ahead of maintenance on these older properties is the best way to avoid habitability complaints and keep your tenants happy. For the full guide to New Hampshire habitability laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for the rest of our state-by-state series.